Okay, Kathleen,
Mhm.
we're ready to go.
All right, great. Well, thank you all for joining the Dallas Association of Young Lawyers CLE entitled 1 Year Later, COVID's Impact on Evictions in Texas. This was organized by the Judiciary and the Aid to the Homeless Committee of DAYL. This is an accredited CLE course, and the course number will be available in the chat both at the beginning and at the end of the program. We will begin momentarily by introducing our esteemed panelists. Also, should you have any questions during the program for our panelists, please note that the Q&A function is enabled, so you can submit your questions using that function below. And we will do our best to get to your questions at the end of this program. My name is Kathleen Cruz from Burke Bogdanovich, and I'm co-chair of the Judiciary Committee. And I have the honor to introduce our first panelist, Judge Juan Hasso. Judge Hasso was elected Justice of the Peace in 1995 per Precinct 5, Place 2 in Dallas County, and he has served Dallas County for the last 26 years. He received a Bachelor of Arts degree in government from Pan America University in 1980 and his JD from the University of Houston School of Law in 1986. Judge Hasso is the recipient of numerous awards, including the 2017 Public Servant of the Year Award presented by the Oak Cliff Chamber of Commerce, and he received the West Dallas Minnesota Alliance Justice Award, which he received in recognition for his outstanding contributions and dedicated service to the West Dallas community in December of 2017.
And Judge Paula Ambrose was elected to the County Court of Law number 4 in Dallas County and has served in that role for almost 3 years. She graduated SMU in 2003 with a Bachelor of Arts degree in Corporate Communications and Public Affairs, and graduated the Texas A&M University School of Law in 2007. Judge Rosales has an illustrious career in public service and private practice, having worked as an assistant district attorney in Dallas from 2008 to 2012, served as a judge for the Dallas Municipal Court number 1 until 2017, and worked as an attorney at Miller Weisbrod until her election to the county court in 2018. We are also told that Judge Rosales is a master chef, yoga extraordinaire, an avid reader, and a connoisseur of fine art. Thank you so much, Judge Hasso and Judge Rosales, for volunteering your time.
Thank you.
Thank you.
So I will take the first question, and this is for Judge Hasso. Can you explain in general the eviction process, like how the eviction proceeding starts and makes its way to your court for those of us in the audience who are not familiar with this process?
Okay, but so generally, the landlord will come in and file their petition with all the information that's needed so that when the citation goes out and it's served by a deputy constable, it has the name of the person, the address. They might include some other information like a phone number, things of that nature. And then generally right now we are setting these cases about 14 to 17 days after it's filed, to give the deputy constable sufficient time to make several attempts to serve the defendant tenant. And if they're not served personally, then they can come and obtain a alternative service, but at least so that they will be served at least 6 days prior to the court date. Prior to that, or when they come to court, one of the things, at least here for the city of Dallas, it doesn't pertain to any of the suburban cities that I know of, because the city of Dallas did pass the eviction ordinance back in April of last year that requires the landlord to give the tenant what's called a COVID notice of possible eviction. And there's specific wording in that notice, and it basically gives the parties 21 days to try and come to some type of arrangement, agreement regarding repayment of whatever might be owed. After 21 days, if nothing's been worked out, then the landlord could give the notice to vacate, whether it's 3 days, 24 hours, 30 days, depending on the circumstances. But that's kind of like the hurdles that the landlord would have to show once they come to court.
And we're definitely going to be very interested in exploring all those hurdles, and we really want to hear your wisdom about that. But so that we can get the lay of the land, Judge Rosales, so we see that they have started at the JP level, these cases. So how does the county court of law get involved?
Right. So for cases that are tried in any of the precincts, I believe 5 precincts for Dallas County, the defendant, usually the defendant, will get 5 days from the day of the Justice of the Peace Court's final judgment or signature on the judgment, will get 5 days to appeal. And they get to do that by either filing a bond, making a cash deposit, or filing a document that is called Statement of Inability to Pay. And that's essentially saying that their resources are too scarce to provide a cash bond. And once they do that, then they file that with the Justice of the Peace Court. The Justice of the Peace Court's clerks, and this is where Judge Hassel can also enlighten us with exactly how that happens. But this court's my court's understanding is that once there's that filing, the clerks for the JP court start preparing the file and send it up to our courts, the county courts at law. Once the county courts at law clerks receive the file, then the notice to all parties that the appeal has been accepted goes out, and typically the defendant has 8 days from the time of receipt of that file to file an answer, a written answer, if one is not on file at the inception of the case, and that is once the original proceeding started at the JP court. So we are a court of appeals in that sense. And once it comes up to the courts, the county courts at law, we are trying these cases de novo. That means that it's essentially a proceeding where we're starting a new trial as if no evidence had been admitted. But one of the great things about working with, or being part of this judiciary system, at least for Dallas County, is a lot of, the Justice of the Peace judges who are, veterans like Judge Hasso, and are actually licensed attorneys. They do oftentimes provide the county courts with certain findings, and so that's actually pretty helpful. And of course, we are trying these cases de novo, but at least it gives us a lay of the land on how the case went. And that's how they make it to us. But the number of cases that are appealed are, frankly, in terms of volume, nothing like the cases that the Justice of the Peace Courts have to preside over. And so I don't know if that answers your question. I can keep on going, but I think Judge Hasso, if he wants to add anything to what I just said, Judge.
Well, basically, once it leaves our courts, we have no further say in it. We don't even know what the results are for the most part. And as I like to tell people that do, after each ruling that I make, I do explain that they do have the right to appeal, and how much time they have to appeal. And if the appeal is perfected, of course, then we send it up to the county clerk's office. They assign it to one of the county courts at law at random, from what I understand, there being 5 of them. And sometimes we'll tell them, and if a county court at law judge rules differently than I did, it won't hurt my feelings one way or the other. That's the whole purpose of having a new trial.
So what happens in the counties where there is no county court of law?
That's actually a question that Judge Hasso and I talked about offline. And of course, Judge Hasso has been part of the JP Courts Association much longer than I've been able to become aware of what they do. But my understanding from Judge Hasso's conversation is that, and there was an illustration of the West West Texas counties
Mhm.
or West Texas region JP courts, where they may not have a county court at law for each county. I believe that they share a county court. Is that how it works, Judge?
Well, after we spoke, I kind of dug a little bit deeper, and it's my understanding that each county, by Texas Constitution, does have one county court. The county courts at law, from what I understand, are statutory, and those were primarily created for counties with larger populations. So it's my understanding, and from what I've read, that each county does have to have one. So I would imagine that in those counties that don't have a county court at law, they would go to the county court that's in that county.
Great. Well, thank you for that overview. Going more specifically into your eviction dockets, Judge Hasso, can you briefly tell us a little bit more about them, like how many eviction cases you currently have and how long these eviction cases take?
Prior to the pandemic and before they shut us down back in March of last year, even though we officially reopened in June, we had been hearing somewhere between 4,500 to 6,000 cases a year. And our precinct was not one of the bigger precincts as far as evictions are concerned. There's others that, from what I understand, we're hearing over 10,000 cases a year. So what we would do is we would have an eviction docket every day at a certain time, which would be 10 o'clock. Whether it was 5 cases, 10, 15, 20. I think the most we ever had in a single day was probably around 40. But since we've come back, and because when they did the plan as to how many people could be in the courtroom, and they told us we could have up to 14 people in the courtroom. What we did was try to limit it to about 10. So what we did was, regardless of how many cases were filed, we would set like 8 to 10 at a certain time, like say 9 o'clock, another 8 to 10, like around 9:30, another 10, like around 10, and 10:30 if need be. We haven't, for the most part, we haven't gone past like 10 o'clock anyway, just because even though we've seen an increase of filings, it hasn't been the tsunami that we've been expecting. And that may come down the road, because I think at this point, I think that part of the moratorium did have, of course, an impact. But even for those that did find out, I guess, that they could also file for lease terminations or lease violations or acts of criminal activity or violence, they started filing those because they knew that those weren't covered by the moratorium. But it's not a whole lot either. But we've been seeing a slight increase, but not the overwhelming tsunami, not like what we used to hear prior to.
And Judge Rosales, can you briefly go over your eviction docket and what that looks like for your court?
Absolutely. So since the pandemic started, of course, there were several, I want to say up to June, like Judge Hasso stated, we at the county courts at law, at least out of my court, we abated all cases. And of course, in addition to following the Texas Supreme Court emergency orders that were live at the time, there's also that CDC declaration, the administrative order from the CDC. And once there was a CDC declaration on file signed by a tenant, my court coordinator would, again, abate the case. Now, that didn't mean that the case would be abated indefinitely. There is a provision within was at least that those orders in back between March and June from the Texas Supreme Court that would allow landlords to challenge the CDC declaration. So those were certain cases that we were still hearing. And these were considered by my court an evidentiary hearing. So the landlords had to had the burden to show that the CDC declaration was improper for whatever reason they wish to argue or allege. But now that we've ramped up a little bit or reopened, so to speak, the eviction trial docket, we are seeing between 4 to 6 eviction cases per week. Out of my court, eviction trials happen on Wednesdays. And the reason we can only have one day is again, still trying to observe CDC guidelines, also the county guidelines in terms of limiting the number of people that are in public spaces. And so, as you know, there are 5 county courts at law, and my colleagues and I share the same floor. We're on the 5th floor at the George Allen Courthouse. So we created as a team, and also through the regional judge, Judge Willis had guidelines for us in terms of coming up with a plan on how we are to limit exposure of folks in public buildings, our courthouse and courtrooms. And so my court can only hear evictions on Wednesdays. And I am having non-jury trials on Tuesdays, but those are my 2 assigned dates, so that my colleagues can in return also have two days of, if necessary, in-person proceedings. But I will say 95% of my eviction trials happen virtually. We have 2 platforms. We have Court Call and Zoom. Zoom has proven to be the most effective, just for folks who are not familiar with the court call process. It takes a little bit to get used to it because you have to establish a relationship with the court call service, and you must dial them and then set up an appointment. Then they issue you a link as well as a conference ID. So the steps are just a little bit longer to follow. And if you're a pro se or a litigant that is self-represented, that may just be a little overwhelming. But with Zoom, so long as they have a good cell phone or access to the internet, they have been able to quickly log in. That being said, my bailiff, Officer Smiles, is at the courthouse on Tuesdays and Wednesdays. And so the physical courtroom is open, and we have a camera and computer, all the technology that we need that is facing counsel table, so that anyone who does not have access to the internet can come in person. And all of our proceedings are broadcasted live, either through our webpage, the county webpage, or through our YouTube channel. So if you Google us or look us up, County Court at Law number 4, county page will have the instructions on how you can observe our public trials. But 4 to 6 cases is what we've been seeing. I want to say probably since February is what this court has been presiding over.
Wow, that is a lot of cases and a lot of trials. Now, Judge Hasso, Judge Rosales, I'm going to ask you both a very loaded question, so feel free to answer as briefly or as long as you like. But many of our viewers do not know just nothing about litigating these eviction cases, myself included. So can you briefly explain what the current law is regarding evictions? Like, what are the elements and defenses and those kinds of things?
Well, like I had said earlier, when both parties are in front of me, in front of the bench, first thing I ask is of the landlord, did you give them a COVID notice of possible eviction and the notice to vacate? I've seen basically for a while there, almost like at the beginning, there was about 70 or 80% that weren't aware of the COVID notice of possible eviction. So I would basically enter judgment for defendant. And even now, there's still a fairly good size of landlords that either still don't know about it, even though the ordinance passed in April of last year, or think that it's no longer in effect. So I kind of like told them, that yes, it is still in effect and they still have to give out that notice. I will say this, and this may be because these apartment complexes that may be part of the Apartment Association of Greater Dallas, I think that's what it's called. They I think give them continuing updates as to the changes in the laws that have been coming down. And I think I've seen or I've read, don't recall who the person is that's now in charge of that association. I think they've made an effort to tell their membership as to how to proceed or how to abate cases themselves. So I think the ones that come have been prepared as far as that's concerned. I've also seen it. So as far as the process, we'll give both sides an opportunity to be heard, of course. But like I said, first of all, the landlord does have to show that they gave the notices and what it's for. Of course, if it's for, like I said earlier, if it's not pertaining to rent, but either lease termination, holding over, criminal activity, lease violations, then they don't have to go the route of giving them the COVID notice of possible eviction, first of all. They might get a judgment for possession, but they wouldn't get a judgment for the rent that's owed. And for the most part, they understand that. And as far as evidence is concerned, then as long as they've overcome those hurdles, for whatever reason it is that they're trying to proceed with the eviction. Now, because the Texas Supreme Court did not extend their order regarding the CDC declaration, all these cases that we had been abating are now going to be set back on the docket. And even ones where the landlord had obtained a writ of possession, as soon as the tenant presented the CDC declaration, everything was abated. So those we're also going to be setting up for basically what's called a status hearing to basically tell them, hey, this CDC declaration is no longer in effect here in the state of Texas. But we're also telling the landlord through instructions from the Justice of the Peace Training Center to let them know that even though the CDC declaration may no longer be in effect, the moratorium is still in effect. And there could be consequences for the landlord regarding fines and criminal sanctions and things of that nature. So we kind of give them the option, we can set this aside still so you can consult with your attorneys to see whether or not to proceed or not. And then it's on them as to whether or not they wish to proceed as far as with the case itself. So, and then of course, on the tenant's part, they would have an opportunity, of course, at this point, it all being due to loss of income, not having a job, or perhaps having had a job, but then lost it again, things that just kind of like one right after the other, then we hear both sides before I enter a decision. And for a while there, and even today, I dismissed or entered judgment for a defendant on like 75% of the cases because the landlord didn't present the necessary documentation as far as the notices are concerned.
Thank you so much for that. And Judge Rosales, have you seen anything different in your court or any other arguments or issues?
Well, what I would say, and I know that several members of this DAYL section may be interested in volunteering or potentially representing either pro se landlords or pro se tenants. And so the first thing that I would tell you is, look at the Texas Rules of Civil Procedure 510. And 510 will give you all that you need to know in terms of how to initiate the proceedings at the JP court, and also provide you with the elements for the pleading requirements. And you have to read that along with Texas Property Code Chapter 24. And that is where you will get your the statutory requirements of if you're the plaintiff, of what you need to show, and how to meet your burden of proof. And the second thing, and I guess really the second or third thing is yes, right now we have the CDC declaration that has been renewed, and is set to expire June 30th of 2021. So it is a federal order, and like Judge Hasso said, the Texas Supreme Court did not readopt that CDC declaration, but it is still in an administrative order that is a national order, and that this court does believe that if the right facts are presented, that the CDC declaration order applies. And so, the first thing you want to do again is, look at TRCP 510, look at Property Code Chapter 24, read all of the Texas Supreme Court emergency orders. Judge Hasso, I believe, correct me if I'm wrong, are we at emergency order number 36?
Somewhere around there.
So, and the reason why I mentioned that is because a lot of these orders refer back to previous issued orders. And so you want to know whether this is a order that completely modifies all orders, or if there are relation back provisions within the current order. And make sure that you also read the CDC declaration. The CDC or administrative order is intended to protect residential contracts, residential leases, or residential tenants. And so, like Judge Hasso, outlined earlier, if the eviction case is for a reason outside of the non-payment of rent, then the case can proceed. And so, a lot of the other contractual provisions between the landlord and the tenant, such as criminal activity happening within the premises, or any other violation of a contractual term, as long as it is not, and of course, all factual dependent types of cases, heavily dependent on facts. But, I don't know what my colleague, Judge Hasso, does in circumstances where there's both a pleading that there is non-payment of rent in addition to other types of violations. And I think that courts do defer in what they ultimately decide to do. So if you are going to be volunteering, representing clients in these sort of proceedings, I would suggest that you get familiar with how each individual court processes these cases. I mean, sometimes, if I see a petition that was originally filed at the Justice of the Peace Court level that started off with a non-payment of rent, and then it comes up to my court, and now what the allegation is, well, wait a minute, there's an amendment, and judge, we're also wanting to enforce is a contractual provision. Then the question is, well, are we dealing with a pretext question, a pretext issue? But I'm going to leave it at that, and I think there may be other questions that can help us explore that concept.
Thank you, Judge Rosales, for that overview. The reason why we wanted to have a CLE like this was just to inform a lot of our members that these types of cases are good cases for volunteer opportunities for young lawyers, or opportunities for pro bono, and we will get into that later in our program. But Judge Hasso, we were talking about the types of difficult situations that tenants or parties come to your court, and they come from various circumstances. such as, you know, when we experienced that snowstorm just in February, or they come from financial hardships. How do those types of circumstances that you see in tenants or plaintiffs that come before, or plaintiffs or defendants that come before your court, how do those circumstances affect those cases?
We actually had a meeting of all the JPs actually via phone, of course, regarding right after the snow ice storm. And even though it wasn't like an official order that we put out, we all came to the consensus that, well, first of all, those cases that we had scheduled for that week, we of course reset them, but reset them for like 2 or 3 weeks down the road, because one, we were going to have to send new notices, make sure that they got them in time and everything like that. And also kind of like put off also issuing writs of possession, even for those that had already obtained judgment prior to the ice storm, for at least 2 or 3 weeks thereafter anyway, just to make sure that, because we knew that there was still going to be issues in people trying to recover from the ice storm as far as that's concerned. So that's how we went about trying to deal with some of those issues regarding the ice storm and things of that nature.
And Judge Rosales, did you have any of those types of circumstances come up in cases before you in your court?
Right. So obviously this 2020 and early 2021 year have been full of surprises, and no one expected the snowvid to be as critical as it really was. So many people, were truly living under inhabitable conditions. And so, as soon as, and I think that this is just really general for Dallas County judges, I believe that we are pretty in tune with what's happening within our community. Mm-hmm. And, my court, specifically my court, was, very quick in doing just what Judge Hasso said, resetting cases. We posted on our Facebook page, we posted on our Dallas County webpage updates, trying to keep the community appraised that yes, we will be canceling. You do not need to risk your life to either make it to the courthouse or try to find a place that has internet access. So, we made sure that, to the extent that we could, let everyone know that their case would be postponed. And I think both the plaintiff and the defendants appreciated that. In terms of other either inclement weather circumstances or sometimes public transportation issues, and this is of course usually pre-COVID, the court will listen to what happened, and if it was a good faith reason for your missing your appointment, the court may consider rescheduling it, particularly if we're dealing with inclement weather. Now, one thing I'll say about that, and I believe that is what all county courts in Texas are supposed to do, or JP courts as well, is although an eviction is approved and there's a final judgment on an eviction should not occur when there is inclement weather. And that means rain, snow, tornado type storms. And so that at least is something that could appease a tenant that is looking at an eviction. I think I answered your question. I don't know if I missed anything.
No, that was a great answer to my question. And just sounds like based on both of your answers, there are extremely hard circumstances that tenants and landlords come to your courts that they are experiencing. Judge Hasso, can you recall any particular case, especially in the time of the pandemic and going all the way up until the snowstorm that we experienced Can you recall any case that stands out to you that you can share with us involving an eviction?
I'd say about 6 months ago, maybe. There was this elderly lady. She looked to be in her mid to late 80s, perhaps. And they're trying to evict her from her house. And what it was that this developer, I guess, in a sense, had bought all these homes from what used to be a nonprofit that was, I guess, at some point trying to help low-income people buy their homes. Something happened where the nonprofit wound up selling all these properties to this for-profit corporation, I guess. And so they filed against this lady, and she showed me this contract that was like almost 40 years old. And she had been paying monthly for years and years and years. And, you know, at some point she said, well, you know, they did contact me, they wanted me to sign something else, and something happened, and this and that. I go, but you were still making payments, right? And she goes, yes, I was making payments. The end result was this. And I don't know if it was something that they didn't explain to her, which I found very disturbing, that at some point, instead of being a sale or for property of the house, it kind of reverted to almost being a tenant, which like I said, I found very disturbing. And she didn't know that. She thought that she was, you know, still paying for her house. And she paid for like 30 or 40 years. And I figured, well, you know, I calculated, had my little calculator. I said, like, if she had made all those payments up to the time that they said that she didn't make any more payments, she would have paid off the house years and years ago. So what I did was this. I told him, listen, I know that, you know, there's something just not right here, you know? So I entered judgment for her. And of course, you know, just as if the tenant defendant loses, they can appeal. I told the developer plaintiff, said, like, you can appeal too if you wish to appeal and take it up to the county court. I hope it didn't land in your court, Judge Rosales, because it was one of those that it would have been kind of difficult. But that's one that stands out recently that I figured I was making a decision based on what she was telling me, the documents she was showing me, that was the right thing to do. It seemed strange to me that this lady, who was now in her mid-80s, thought she owned the house, was being evicted from a house that she thought she had paid for years ago. So anyway, I just figured, no, that's not right. But anyway, that's the one that sticks out most recently.
Thank you, Judge Hasso. Judge Rosales, did you have any similar cases in any way that stood out to you?
Yes, so we have, and I think that's an excellent point, particularly for tenants.
Oh, Judge Rosales, I think we might have.
Who cracks. Can you hear me now?
Perfect.
Oh. Okay, I had a notice saying that my internet connection was unstable. So let me just start over. And I think I was hoping that Judge Hasso would touch on that, because a lot of underrepresented litigants who come into our courts, and when I say underrepresented, usually at the time that they enter into a contract with a seller, They enter into a contract really not knowing the intricacies of how it is that they're going to eventually show that they have been making payments on time. They come into our courts and they say, Judge, and they show us, a little either handwritten piece of paper or, some written document that will have some terms and there is consideration. So your elements of contract will be contained within that, informal piece of paper. But then there's the allegation by the seller who is now trying to evict this buyer that payments were not made in due time. And so one of the questions that I have to ask is, are we dealing with a question of title? Is title so intertwined with possession that I don't even have jurisdiction over these cases? That would have to be a battle that needs to be taken at the district court level. And those are, in fact, during this COVID-19 pandemic period, I have seen, these are lots of the cases that we actually get to try. And trying to come up with that answer, the court also must question herself and say, was there ever a landlord-tenant relationship? And if there's not a landlord-tenant relationship, they can't just use the eviction process to skip over the title dispute. And so it is certainly, again, very fact dependent. And hopefully the defendant will have legal representation. And I think that's where, attorneys who are willing to volunteer can certainly help. If this is a contractual case, all of the defenses in a contract are available. And so, that's certainly, I'm glad that we touched on that kind of, fact pattern. Another case that, sticks to my mind during the COVID-19 pandemic is again, going back to the topic of pretext. So now, of course, we have plaintiffs who wish to assert their right to enforce contractual terms for again, either there's criminal activity occurring on the premises. There is an occupant that was not approved by the landlord to be living in the premises that has, been living there for over the contractual allowable term, usually 14 days or 14 consecutive days, if they follow a certain form contract. And I had one case where it was a couple. I don't recall whether or not they were married, but this couple would be heard by next door neighbors to be arguing a lot. So they were shouting within their apartment, and the police was called on various occasions. And what ensued once the court started trying to address the evidence in the case, this couple, the woman was being a victim of family violence, but the plaintiff, the landlord, wanted to evict everybody. Both the male, in this case, it was a male woman couple, evicting the male, the female, and their children. Why? Because there was disturbance of the peace of the other tenants or neighbors. Potentially criminal activity had occurred within the premises. Police was being called, so that was interfering with the peaceful enjoyment of others' premise or others' living arrangements. And the tenant, the woman, was able to show, one, that her husband had left, and two, that she had actually secured a temporary restraining order from a criminal district court that was going to be valid for 3 years, from the time of the signing. And so, yes, surely she was part of the contract or the lease. Yes, if you're a bypasser and you see police activity, you may believe that anyone who is living within that premise could have been involved in some form of criminal activity. But once you explore it a little bit further, you realize that now we have a victim. And so you're not going to convince the court that having a victim of family violence is going to be a violation of the contract. So that's another case that sticks out.
Oh, and these sound like really complicated factually cases that probably involved a lot of investigation on the court's part and also on the party's part. Can we talk a bit more about the moratoria and other programs? And I guess you already touched upon this, Judge Hassel and Judge Rosales, but if a tenant is not aware of the moratoria or other programs, so does the court do something to alert them about this? Does this happen in the hearing or some order in advance, or are your hands essentially tied and it's really up to the tenant to discover all these programs?
So when the citation goes out, the very last page actually is a flyer that we've downloaded from the Texas Eviction Diversion Program. And it has the criteria on there and a website and a phone number for them to call for rent relief programs, of course. But like anybody else, people get served with a citation. Sometimes they don't even open it. They don't read it. There's several pages, 4 or 5 pages, and they might not even get to the last page. So what I'll do when they come in, ask them if they've applied for any of the rent relief programs. And some of them will. In fact, I've seen more recently. And like I said, I think it's more primarily apartment complexes that may be members of the apartment association. Because when I asked the tenant, if they've applied, a lot of them are saying like, well, yes, in fact, they helped me apply. So some of these apartment complexes, the ones that are more enlightened, I guess, are taking proactive steps to help their tenants apply. Because one, I mean, it's good for the apartment complex, because if they get accepted, the back rent is going to get paid. And two, the tenant will get to stay. So because from what I read last week, I believe, out of thousands and thousands of applications that are only sent out like 250 checks. That's kind of like mind-boggling. And you understand there's going to be some glitches here and there when a program is first starting, and it's going to take a while. And that's why they made that provision that if both sides are in agreement, they're going to participate. We can set the case aside for 60 days. And we've been doing that in a lot of circumstances where both sides are saying, yes, we're going through this program, so on and so forth. I said, well, I'll tell you what, we're going to set it for 60 days because this process is just starting. It's going to take a while for it to be approved, and so we've been setting a lot of these cases for 60 days and up. We've had a few that I think one today said that they were like at the second stage, which is good because it means they're progressing. And some of these landlords, like I said, some of the bigger complexes that are familiar or aware, and they're in agreement. And one came in today that I reset from last week. And basically they said that they wanted to dismiss it. The tenant had a $2,000 check, not from the program, but of his own money. But they were still going through the rent relief program as well. And they said like, no, we'll dismiss it. So we've seen some of that. I think where you get into some of the ones that are uninformed, perhaps, are it's people that they're landlords, but they're not big landlords. They might have a couple of houses here and there to supplement their income. They're not familiar with all the processes. But I think for the most part, I think you're seeing some of the bigger complexes assisting their tenants in applying. Because I think they realize that, hey, if my tenants get accepted, they're going to receive monies from the state.
Judge Rosales?
That has been also this court's pleasant surprise is how much the landlords have been willing to, follow with these rental assistance programs and try to assist their tenants in enrolling. There is a lot of there are a lot of funds out there that folks can qualify for. And I want to say over the past 3 weeks, I've had, several cases requested by both sides to be reset so that the parties can continue engaging in these conversations. Of course, as a trial court, we cannot provide legal advice to either side. And we try to make sure that the parties understand that, but certainly we can provide within that limit, information about how justice is administered. And one thing that this court was doing when automatically abating cases under the Texas Supreme Court's emergency orders, as well as the CDC administrative order, once we administratively abated the case, my court would also send a copy of the CDC declaration to both sides, so the landlord and the tenant. But the CDC declaration information must be contained within the citation. So, unfortunately, if the tenant doesn't take the time to look at what is contained therein, at that point, the question is, have they exercised their due diligence? Which is why attorneys such as your committee members and your members in general could come in and help them understand those 5 to 7 pages of the citation and petition.
Thank you, Judge Rosales. I'm going to wrap up since our time is coming to an end, but with our last question, thinking about the future and the pandemic hopefully coming to an end with more people getting vaccinated and more people returning to work. But with the CDC moratorium also lifting, do you expect that the eviction crisis to continue with a new flood of cases? And do you think that the need will still be great for our members or young attorneys to help out on these eviction cases? Judge Hasso, sorry.
Well, at this point, like I said earlier, we haven't seen the anticipated tsunami. That might come down the road. We don't know yet. I think a lot of landlords are kind of holding back still. And especially with the rent relief programs out there as well. Some of them may be holding back also because of the moratorium, of course. Legal consequences that might come from that as well. But I think attorneys like Mark Melton and others that are out there trying to help the tenants, and if somebody wants to volunteer, probably should contact Mr. Melton or the Dallas Bar or Legal Aid and see how they can get involved as well.
I echo all that, absolutely. I think the Dallas Evictions 2020 organization has been able to help, I believe, over 6,000 individuals. The Legal Aid of North Texas, the DVAP, this committee, all great resources. I was looking at the CDC temporary halt in residential eviction, so the newest version. And there's some discussion about what certain researchers have found, and they are, that order does highlight that although there was a 50% decrease in eviction filings during this pandemic period, that there are still over 100,000 evictions that have been filed since September of 2020. And so that would suggest a high demand and likelihood of mass evictions. And yes, I am a bit concerned about how we are going to be handling, like Judge Hasso said, a potential tsunami of these sort of cases. You know, in addition to the eviction trial docket, I know the Justice of the Peace Courts have other types of trial dockets, and so do we. And so when is it that we're going to be able to fit everyone in? The statute says that eviction cases will, on appeal, at least take precedence over any other hearing or trials. And so if our dockets start filling up, you know, my team is at least trying to figure out how we're going to be able to open the doors of justice and give you all access to our court system on other matters if we have such a mass in eviction filings. But for now, you know, the cases that this court has abated, unless the CDC declaration has been challenged, they still remain closed. So, you know, if there's a way for this committee to encourage representing, you know, pro bono clients and maybe even working with the Justice of the Peace Courts and the county courts at law and trying to coming with, you know, certain solutions on how you all as a team could come in, that would be something that I would be more than happy to discuss. If I had, you know, unlimited resources, which our courts don't, I would also have social workers, you know, next door. And as a community court judge, when I was a municipal court judge, you know, having a social worker was so effective because, again, we cannot provide legal advice. And but what the social worker is able to do is determine the individual circumstances of each individual that comes before the court and try to find those programs, those rental assistance programs that they may not be aware of, another, you know, potentially employment opportunities, applying for life skills classes, also sometimes how to apply for governmental IDs if they've been lost, et cetera, et cetera. But I think that is a topic for a different day. I think we're running out of time.
Thank you so much, Judge Hasso, Judge Rosales. We got a lot of audience questions from the audience, but we want to respect your time. So I'm really going to ask only one so that we can try to wrap this up in the next few minutes. So we talked a lot about all these steps and all these arguments, but what happens if an appeal is filed not perfected, or a tenant does not respond in time or show up in time? Essentially, is there like a default in an eviction in the various steps of the process that can just lead to a summary eviction or a summary judgment against a tenant?
Well, as far as at the JP level, if the tenant doesn't show up, we still have to inquire, since in JP court we can develop the case ourselves, and that's why I still ask even if the tenant doesn't show up, I will ask the landlord or the representative of the landlord first to show that they sent out the COVID notice of possible eviction. Of course, like I said earlier, this is just the city of Dallas, might not apply to any of the suburban cities. And then after that, did they subsequently send a notice to vacate if it's a non-payment of rent case? And if they can't show that to me, then I will go ahead and still enter judgment for defendant, because the plaintiff did not prove up their case. And that's one way that we handle as far as if the tenant doesn't show up, as far as that's concerned.
Right, absolutely. Similarly in county courts, there's not a summary judgment process. We don't have enough time to engage in an MSJ proceeding, but a default judgment, if that is what the plaintiff is requesting, they still must carry their burden of proof. They still must be able to meet their elements. And if they cannot, the court will enter a judgment in favor of the defendant. Yeah. Oh, and was there another question?
No, I guess only on appeal, since you also mentioned earlier that there's a time period to file the appeals, and that if a tenant say comes a week late or a few weeks late and still wishes to appeal, is there a way to go around that, or is a tenant essentially barred from appealing if they do not request it within the prescribed time limits? Does it essentially strip the county court of jurisdiction, I guess?
So from the JP at the JP level, they do have the 5 days to move out or appeal. Now, because we actually close prior to 5 o'clock, they actually get a 6th day as far as the appeal is concerned. But yeah, if they don't appeal within that period of time, then after the 6th day, the landlord could come in and obtain the writ of possession. I don't know what at the next level, perhaps Judge Rosales can address that.
Right. So if a case is opened by the county clerks, the court will proceed with hearing an appeal. And that is even if the bond was not posted, so long as we actually receive the Justice of the Peace Court clerk's file and we accept it and we create a cause number, it's on our docket and we will adjudicate the case through the trial process. Oftentimes, the pleadings may be a bit confusing or missing somehow, depending on the reasoners or the explanations provided by the litigants. The court may grant a very short continuance to help them or to give them an opportunity to cure pleading defects.
Well, thank you so much, Judge Hasso and Judge Rosales, for taking the time to educate all of us about the eviction law and inspiring and encouraging us to be more involved in these pro bono cases. This has been very informative for me personally, and I'm sure all of our viewers agree. And thank you to everyone who could join us today. Before you log off, please note that the CLE course number can be found in the chat. And for those who want to get involved in representing defendants in or landlords, tenants or landlords in eviction cases, please reach out to the Dallas Volunteer Attorney Program and Dallas Evictions 2020, which are two organizations. We're always looking for attorney volunteers to help with indigent clients. The contact information for those organizations can be found in the chat as well. And also, if you want to get involved in DAYL's Aid to the Homeless, which Eugene is co-chair of, or the Judiciary Committee, please reach out to Sherry Harris, whose email address can be found in the chat too.
If I may, I think you had said that there was other questions that we didn't get to. If I might suggest, if you have them written out, if you could put them together and shoot them off to me, I'll try and answer them and send it back to you as quick as I can. Because I know it's like when sometimes I go to seminars, I've got a question that was never addressed, and it kind of bugs me. So yeah, if you have these questions written out, send them to me and I'll go through them and I'll try and answer them as best as I can. Okay?
Thank you, Judge Hasso.
Thank you so much.
Okay, it was fun.
Thank you for letting me participate today with one of my mentors, Judge Hasso, and congratulations to Ms. Cruz and Mr. Timchenko on a very well-run CLE, so I appreciate it.
And before you log off, judges, I'm sorry,
mentor. Excuse me, she says mentor, but what I hear when she says mentor, she's just saying that I'm much older than she is.
No, no, Judge, respectfully disagree.
Thank you so much. Bye.
But before you log up, judges, I understand that Sherry wanted to take a picture for our Bolton and other for DAYL. So if you could just hold on for 5 seconds while she does so, and we can
take my glasses off.
Got it. Thank you.
Thank you so much.
Great.
Thank you.
Bye.
Bye.